Hi, Jeff Marsace here, and today we're going to talk about protective planning for inheritances. So we're not talking about protecting your assets for you, we're talking about protecting it into and through the whole next generation. Now, what I often hear from clients is they have a concern that, and the big one is, well, we love our son-in-law or we love our daughter-in-law, but we really want to make sure that our estate will go down to our grandchildren. Nothing against the spouse, but as people see, there's often a divorce rate, but there's also a decent remarriage rate after a spouse passes on. And the concern is, well, what if we have 2 children, we have a son and a daughter, we leave half of everything to our son. So we pass on, our son inherits everything, and then our son passes on, leaving it to our daughter-in-law. And then the daughter-in-law gets remarried. And then the daughter-in-law ends up dying and leaving everything to the new spouse. So all of this inherited money that was supposed to go down to the grandkids is going to the grandkids' stepfather. And that's not something that a lot of my clients are comfortable with. So one big reason is ensuring that it eventually goes down to the grandkids. Another one is they're concerned, maybe because of the child's profession, that there could be a lawsuit. Or if they're involved in business, there's always a possibility of bankruptcy, or just plain on, I'm afraid that they'll waste it and not provide anything for the grandkids. So we do have several things that we can do. The biggest and first one is we always have to start with looking at the vulnerabilities and when are things vulnerable, and the revocable trust helps reduce greatly the possibility of problems at the time of death, someone contesting the estate. So why exactly does a revocable trust provide more protection than, say, just doing a last will and testament? Well, it really kind of comes down to an industry thing and the way things are set up. And I'll tell my clients the story all the time, or give this example all the time. If someone goes into an attorney's office and they said, my dad died, he had a will, and he left 75% to my sister and 25% to me. I think my sister was whispering in his ear and he wasn't doing too well in the last couple of years. I think he was out of his mind, and I want to fight this and I want to contest this. Well, a lot of attorneys who do that work, and I don't, by the way, will end up saying, sure, we'll take the case. The reason is there is a very good chance that they're going to get paid out of the estate as part of this contest process, whether they're successful or not. So the attorney's really got nothing to lose. Well, now let's take that same exact scenario. My father wasn't doing too well. He left 75% to my sister through his revocable trust. And I only got 25%, and I think my sister was whispering in his ear, and I want you to contest this trust. And the attorney says, sure, well, we'll probably need about $15,000 to get started. And whoa, wait a minute. No, you don't get paid until I get paid. No, it doesn't work like that, because we're not talking about contesting something in probate. We're talking about a civil lawsuit in civil court, where they're not going to very readily award attorney's fees for this type of contest. There has to be, really, they've got to show that it really was some type of undue influence, or the father had diminished capacity, and the attorneys don't work for free. That's just the way it is. So cutting off a potential contest starts at that revocable trust level, and it greatly reduces, or in a lot of cases, it just eliminates that possibility of contesting the trust at that initial level. Now, can somebody contest a trust? Of course they can. Anyone can contest anything they want. The problem is, will they win? We don't know. But I know that people who want something that they're not entitled to very rarely want to put up their own money to try to fight it. So having this plan laid out initially in a revocable trust and pulling the assets out of the probate process is already a huge amount of protection. But we're not just looking at the children's level and making sure it goes to the children. We're talking about extending that through another generation. So we have a couple of other trusts that, in combination with the revocable trust, really nails down the protection for not just the next generation, but getting it to the generation after that. So the first big trust is the beneficiary trust, and the second one is the IRA trust. It's in combination that these two trusts work. The beneficiary trust is for your regular non-tax deferred or non-tax free assets. The IRA trust takes care of tax deferred assets, retirement accounts, or tax free accounts like Roth IRAs. You've converted a regular IRA to a Roth, or you've contributed to a Roth and you're passing that down. So let's talk about the beneficiary trust first. All right, for the beneficiary trust, it's extremely useful to protect those assets. Well, why is it protecting these assets? Once assets are in an irrevocable trust and there is a trustee in charge other than the beneficiary, and the whole inheritance is at the discretion of the trustee. In other words, the beneficiary can't demand money come out and you have to listen to them. Now it's protected from lawsuits. It's also protected from divorcing spouses. And in most cases, you talk to any divorce attorney, they're going to tell you, oh, if you get an inheritance, that's not on the table for a divorce. That's true, but what do most people do? Oh, I got an inheritance check. What am I going to do? Let's put it in the joint bank account. Done. Protection's lost. If it's inside the beneficiary trust, it eliminates that possibility of, quote, accidentally commingling the assets. It's also going to protect from bankruptcy and wasteful spending. If that particular beneficiary would just take the money and run, well, they're not the trustee of their own beneficiary trust, so that's not likely to happen. So, one question that I often get is, well, can't we just do all of this through the revocable trust? Well, it gets extraordinarily complicated when you do it that way. And the big thing that happens all the time is if it's going long term and it's going for the whole life of multiple children, one child gets money from their share of the revocable trust, which is now irrevocable. And then suddenly the other child's like, well, why didn't you give me money? It's our trust. If we separate it out at the time that the parents pass on, and it gets divided into that separate beneficiary trust for each child, one child's taking money out, it's coming out of their trust. As simple as this sounds, it really is a huge factor, because children tend to feel cheated if they're not getting exactly the same things out of what's supposedly a group trust. But it's very clear that this is their money, and this is this person's money, and this is this person's money. It just makes things so much easier. The other thing is, often you want adult children that you trust to be in charge of things, and you can't have a child in charge of their own beneficiary trust and still have that protection. So I often see where siblings are like trustees of each other's trusts, so that the brothers and sisters are looking out for each other. You can't very easily do that with shares inside the revocable trust. So it's best to have one beneficiary trust for each child. And then when the child passes on, their share goes down to their children, not to their spouse. So it's held up in this beneficiary trust. It's for their benefit. A trust could buy a house and they can live in it. Your child and their spouse can live in the house, enjoy it. Oh, we're taking a trip. Call up the sister. She's the trustee. I want $5,000. We're going to take a nice little trip. And the family, okay, sure, here's your $5,000. But the whole chunk, the principal, when it goes down to the grandchildren, it's bypassing the spouse because that's, quote, grandma and grandpa's money. It's going down to the grandchildren. It keeps it separate. It keeps it protected during the child's life and makes sure that it goes down to those grandchildren. Now, there are some other tax complications in there and choices and whatnot, but that's something that's more suitable for one-on-one questions. But that's the beneficiary trust. Now, what about the IRA trust? Well, that's really the same thing, except it's for tax-deferred assets. So in other words, it's going to protect IRAs and 401ks, but it's got some very specific tax language that allows that inherited money to not be taxed all at once. And then it can grow, but not grow tax deferred. No, when you've got an IRA trust, you can set up an inherited IRA. Now it works whether it's a 401k, a KEO, 403bs, whatever. It goes into each individual IRA trust, one for each child. It gets set up and placed into an inherited IRA owned by the IRA trust. And then only small portions have to come out over time, over the lifetime of the beneficiary. And those portions get taxed. But it's not taxed all at once. And that money inside the inherited IRA, that's still growing tax deferred. So it's a lot better tax-wise. It's a lot better growth-wise because it keeps growing without having to take out huge amounts of money for taxes. And there's more money to compound. Now, I could go in and talk about the compounding and all the other tax stuff, but I actually have a book called the IRA Trust. So you should be able to get that if you really want to dig into it. You can call our office and we can send one out to you. But there's a very important and very recent development which came down because some of the courts were split saying, oh, if it just went from the parents into a child's inherited IRA, that it's protected from lawsuits and bankruptcy. We just had a U.S. Supreme Court case where someone tried to claim that bankruptcy didn't affect an inherited IRA because it doesn't affect IRAs. No, IRAs are your own retirement account assets that you're putting your money away for your retirement, and it's in a tax-deferred, or in the case of a Roth, a tax-free account. It's classified as retirement accounts, and that's not subject to bankruptcy. But when you inherit someone else's retirement accounts, and there are some tax breaks associated with it, like with an inherited IRA, that's not going to get bankruptcy protection, and the Supreme Court really just came down with that. And all of the theories and all of the reasonings behind this decision are really pointing to the fact that you're not going to be allowed to claim that creditor protection in a lawsuit either. So if you really want to protect this money, just telling your child, oh, set up an inherited IRA, that's not going to provide the lawsuit and the bankruptcy protection at all. It's going to have to be in the form of an IRA trust. And then, just like with the beneficiary trust, for whatever money is left over, when the child dies, it's going down to their children. In other words, the grandchildren. So, by the use of a revocable trust at the start, dividing out the assets into beneficiary trusts for the next generation, and then having it, when that child dies, go down to their descendants, you've really protected and shepherded that money down to the children, and then what's left down to the grandchildren without getting the spouses involved, and while providing lawsuit, bankruptcy, divorce, and wasteful spending protection for that whole generation. So I'm seeing a lot more of my clients look to this as the best way to make sure that their family is going to maximize whatever inheritance they're going to leave them. So there's plenty more that I could talk about, but this is supposed to be a quick video, and I'm probably past the point where it's quick. So again, I'm Jeff Mersacci. I hope you've enjoyed this video and you learned something. And if you need anything, just let us know. Thanks and have a great day.